Just by way of simple introduction, my name is John Mann. I'm an assistant state engineer with the Division of Water Rights. I generally do hearings and oversee the applications and records processes in the division. And so I've noticed that my compatriots who have spoken to you previously haven't made any attempt to wind up telling any kind of joke. I thought about maybe giving some sort of lame attempt at humor, but I enjoy public speaking so much that I'm kind of like an old car, you know. I hope that if my radiator leaks or my exhaust backfires, you'll be compassionate and understanding, especially given that some of you are a similar age to me. But yeah, anyway, you might think of advanced water right topics. What the heck is that, okay? It's probably those that are most controversial. Now then, you good folks that are from PO and Camas, you probably think of a advanced water right topic or a controversial one as being something that's a simple change application to have a domestic use that's somewhere, and in some places within the state that's probably true. But I'm going to try to kind of keep my topics to those that are listed on this particular slide. And with that, again, if you get nothing else out of the training that you have participated in, I hope it's an understanding of the very basics of water rights. And I've listed a few of them here because it doesn't really matter what level or type of water right topic you're dealing with, whether it's the group contribution thing that Teresa talked about, you're basically dealing with the basics, okay? So you're going through and you're trying to identify exactly what the water right is and what that unique beneficial use is that's attributable to a water right. That affects every application, every type of application that's filed within the division. And in case you are misled by the idea that water somehow underground comes from some deep cavernous location and magically is an aquifer, I want to confirm to you that all water within the state originates as precipitation, okay? Whether it's a stream, whether it's a spring, whether it's within something that's a well, okay? Now, let's kind of get down here again a little deeper into some of these water quantity things. These have been mentioned in previous slides. I don't want to belabor this sort of stuff, but you'll notice that I have a Utah Code annotation up at the top, 7312. And I want to make sure that you kind of hearken back to your high school civics classes. Okay, in Utah there are three branches of government. There's the executive, the legislative, and the judicial. The legislature goes through and they adopt laws. The executive branch, of which the division is part of, actually implements those laws. And so that's what the division is about. We're here to wind up, the state engineer is charged with administering water rights within the state. Now, some examples of some of these controversial types of rights that you might be familiar with would be things like the nuclear power plant that was mentioned by Mark Stilson on the Green River. Okay, big application, lots of people interested in that, water right users and those that are not water right users. Other things might be like usage of water on the Colorado River. What about the Lake Powell pipeline, which dovetails with that concept? Some of you here may be from southern Utah, and so we have an application, some applications that were filed not too long ago within Beaver County for the Central Iron County Water Conservancy District. Those are export applications, which are intended to help resolve water supply issues in the aquifers in Iron County around Cedar City. Then you have other interstate types of issues. You have groundwater issues out between Nevada and Utah, other types of issues between Utah and Idaho, particularly related to the Bear River. And so I have a couple of different little questions here on this particular slide. And I want to make sure that you appreciate how water rights are evaluated and how these really basic concepts, and I'm sure you think you know, well, I know what a flow is. It's a gallon per minute or it's a cubic foot per second, okay? I know what a volume is. It's an acre foot or it's some other quantification of a fixed amount of a container of water, if you will, okay? But when you're thinking about it within the context of water rights, why is that of significance? go down there to the bottom, the very bottom, and let's say that you have a water right, and you have to understand that it has only been within the last, say, 25 years, roughly, that the division has really shifted its focus from water rights being established for flow rates to quantifying them in acre feet. Okay? So we're taking an apple in some cases and trying to incorporate it into some sort of fruit salad that comes out on the other end as being something that is a little easier to manage in some ways. But so let's say that you have the first instance here. You have a half a second foot right, and it's to irrigate 10 acres. What pops up to you about that? Oh, I'm sorry? Okay, it better be sprinkled. Okay, half a second foot to irrigate 10 acres. Any of you here that are active farmers? I know, Mr. Wilden, you're an active farmer. If you had a half a second foot, how much would you expect to irrigate with that?
Half a second foot makes about 1 acre foot a day.
Right.
So, and on a crop, you do what, 3 acre feet a year?
But just from a practical standpoint.
It'll run a quarter-mile sprinkler line.
Okay, so that's a lot more than 10 acres, is it not? Generally speaking, in some decrees and things like that, again, it's not an insignificant amount of water, but I mean it's not a lot of water. The Weber River Decree, for example, within their estimations and allotments of water, they allocated 1 second foot for every 80 acres. And so if you went through and you took a hard look at this half a second foot, it would probably irrigate somewhere around 40 or 50 acres. In ballpark. And it depends on the farmer, it depends on the method of irrigation, all those sorts of things. But if you're seeing that half a second foot and the beneficial use is to irrigate 10 acres.
Are you saying half a second foot or half a foot per second?
Same thing.
That is, okay.
Second foot, cubic foot per second, same thing. Okay? Anyway, but let's say that the water right owner all of a sudden decides, well, I've got the town of Providence that's out there and they're in the market to buy a water right. I want to sell them this water right. If you're the town of Providence, how do you wind up evaluating what you're willing to pay for this water right? What is it? Any idea? Okay, we talked previously about duties of water, of the beneficial use. So if you say that the duty in that area is, let's say 4 acre feet per acre, you have 10 acres, that's about 40 acre feet, right? Okay, if you have a half a second foot, the seller wants to sell you the half of a cubic foot per second. How many acre foot is that? Mr. Wilton hit it on the head. It's 1 acre foot per day for 7/12 of the year, which comes out to about 213 roughly acre feet. A little bit of a disparity, is there not? So when you're in the business of evaluating these water rights, whether you're the seller or the buyer or someone that's in between as a real estate agent or a consultant, keep these kinds of things in mind, okay? If you have the second case, you have a half a second feet and its claimed beneficial use is to irrigate 200 acres, what kinds of flags go off in your head for that? What do you think? You just listened to Teresa for an hour and a half talking about supplemental groups. Might it be the case that this would be a water right used in a supplemental group? In as much as for example, the 4 acre feet per acre times 200 would be 800 acre feet. So would you shift your thinking to, well, maybe this isn't the only beneficial use that is, or water right that is being made for this particular beneficial use, okay? So there are lots of different types of things that, that might come up. And again, you know, you see people all the time that wind up thinking that, well, they have a group of water rights, like they're an irrigation company, they have a high water right, they have a low water right, something else, a storage right, and they think, well, we don't use this particular water right anymore. We're going to wind up selling that so that we can get money into the company to make improvements to the company or something like that, and hopefully hold on to these more senior rights, and then we don't have to give anything up. It's not the case. In order to file a change application, you have to give up something of equivalent value to that which you're trying to dispose of, to sell, okay? I have a lot more material here than I'm going to be able to cover, but just briefly, I have a slide here of the Great Salt Lake. And you might notice that it has peaks, valleys. It ranges from about 4192 in elevation to about 4212, which is what it hit, pretty close to it in the 83, 84 flood years, just after that anyway, when the lake was at the all-time high. Now, why would I show this slide? Mainly because I have a bizarre sense of humor, or a way of looking at things, but Great Salt Lake is at the bottom of the bathtub, if you will. And so what happens within the Great Salt Lake is sort of reflective of water years and water conditions around the state. You'll notice in those years in which it was rising. Let me see if I can do this. Anyway, like these years that are interpreted from 1845 to about 1875. Pioneers came into the valley, the Great Salt Lake was rising. You could infer from that that they had pretty good water years to deal with. From 1875 all the way down here to about 1905, okay? Not so good water years. The lake was falling. Same thing, it fluctuated a little bit. Over here in the mid-60s, the lake was at its all-time low. The legislature was having a little bit of a fit and wringing their hands about what do we do about the Great Salt Lake? Well, anyway, lo and behold, they entered another pattern where they had good water years and it began to rise. And then this little spike right here was indicative of the effects of 83, 84, when we had water running everywhere. Down 1300 South, or whatever it was here in Salt Lake City, when they converted that into a waterway. Right now, the Great Salt Lake's in here about 4194-ish, give or take. Hopefully, it'll continue to wind up climbing, and we will have more water to deal with within the state. It certainly makes these water right issues easier to wind up dealing with. But again, that's one reason to kind of keep your eye on the Great Salt Lake and what's happening. We recently had some interactions with some of the industries on the Great Salt Lake, and the brine shrimpers and some of those people would be very happy if the Great Salt Lake would rise again, so they didn't have to wind up going through about a mile of shoreline to get to the lake to wind up launching their boats and that kind of thing. So again, it does impact what some of those people. But again, I just want to emphasize one more time that the beneficial use is where the rubber hits the road for water rights, okay? Anyway, but it's kind of a matter of what did the water user actually do with the water. That's all we're saying when we say beneficial use. And we've talked a lot about change applications. There's basically two types, permanent or temporary. They usually want to change the elements that are shown. And as I've indicated, when you file a change application, the intent is that you give up something in order to get something. There are all kinds of different aspects of change applications that I won't go into, but again, the main thing that we're looking for is an evaluation of the right, and then to make sure that it's not enlarged as they go through and they wind up pursuing that change application. And then one other thing, diversion and depletion. We've talked about it kind of ad nauseum here, but there you go. A couple of good quick definitions of what those are. Now, I'm assuming you guys are all super intelligent, way more than me, and you understand these concepts, so I'm hoping that is helpful. Just as a refresher on what was talked about primarily yesterday, we've talked also about duties and how we've adapted duties of water to wind up helping to make these water rights that have historically been established something that's a little more easily managed. Okay, so again, nothing magic about it. These depletion values, they're actually, if you look at that link down there at the bottom of the page, you go out on the division's website, there's a calculator that'll help you figure if you have X number of livestock, whether they be chickens, turkeys, sheep, whatever, how they all equate to equivalent livestock units and how much water you would need in given areas. Okay, now I plugged this slide in here in order to wind up introducing a little more practical aspect again to some of the things that are considered. All of you know what a hydrograph is, right? I just showed you one of the Great Salt Lake. It's time versus water. In the case of the Great Salt Lake, it was water level. In this case, it's flow. You can see over here along this left side, you have flow rates in cubic feet per second, 50, 100, 150, 200, up to 250. And then this little box up here, it talks about 3 separate water rights that are established on this stream. And the first one has a priority date of, I believe that's 1873, right. 1922 and then 1949. Sometimes these bifocals work, but anyway. And then they're depicted, this first one, 1873, by this red line. And so within this stream flow, you have these lines, these horizontal lines that are colored, represent the start of the irrigation season in April 1st and the end of the irrigation season in October 31st. Okay? So everything that is below this red line falls within the right of the 1873 water right to divert that water. So when do they get a full supply? Anyone want to volunteer an answer? If you don't want to be interactive, that's fine. Starts right over here. Okay, they're getting a full supply anytime this blue line is exceeding the red line. So right through there, a little dab right over here. But these fringe seasons, typically this would be after the runoff has occurred, would be August, September, October, sometimes before the runoff starts over here. In the front of the year, where you're talking about the first parts of April, those stream flows haven't picked up due to the runoff, and so they don't get a full supply. Now, so the 1949 right, I'm sorry, the 1922 right, you have that represented by this orange line. When do they get when is it their turn to divert? Anytime you have more than 25 second feet in the stream, this red line would be a right of about 25 second feet, okay? You go over here to this other scale, and that's about what that is, about 25 cubic feet per second. So more than 25 feet per second, they have the opportunity to divert water up to about, it's around 60 second feet would be the difference between these two lines. Okay? So you can see there's an area in there in a period of time in which they are entitled to divert water. But they don't get a full season. There's the beginning of the irrigation season, the end of the irrigation season. Lots of gaps in there for that particular right. The next priority right would be this 1949 right up here represented by the green line. And so they get water right up here and then a little bit down through here too. Okay, but it's anything that's in excess of the 60 second feet plus the 25 second feet, then it's their turn. And so you might think, well, why am I showing you this again? Okay, I'm trying to point out that if an irrigation company comes in, let's say that they own all 3 of these water rights. If they're going to file a change application to go to a well, and they want to use, say, this most junior water right, that's up here, anything between the orange and the green lines, and you're down in the valley, and you have a well that you rely on, perhaps for a town supply, perhaps for an individual domestic supply, and they want to use that particular water right, how do you want that evaluated? Are you concerned about their particular application? I guarantee you should be. The impact of this would be, again, that they're taking a right that really only gets water for a couple of months over there and attempting to extend it so that they get a fuller irrigation supply. So that means they're going to be drafting on the groundwater something that may or may not be there. Okay? Anyway, but those are the kinds of things that we're trying to weigh when we receive applications to wind up making changes to existing water rights. So I'm not going to belabor this anymore. If you have any misconception that Utah is the second driest state in the nation, I want to wind up dispelling that also. This is a chart that shows these are mountain snow-tell sites, okay? And this is the 10-year average is right here. And you'll see that it's about 32 second feet, give or take, I think. 32 inches of precipitation. And these little rectangular boxes down here along these vertical bars, that represents a water year. So at the bottom is October, and then it goes through November, December, January, February, all the way up through September at the very top. And again, keep in mind that this is a 10-year average over here, and you can see there are 11 of these years that are depicted, and there's only about one of them right here that where it hit the average, but there's 3 of them in there that it exceeded it. The rest are below that. So those are the mountain sites. This is the rest of the state. You can kind of see again that within the state there's probably about at least a third of the state. If you go back over here under this legend thing over here where it says under 10 inches of precipitation annually, most of the state, there's probably a third of the state that receives less than 10 inches, and probably 80% of the state gets anywhere from 10 to 15 inches. I would guess that most of that's closer to the 10 inches than it is the 15. Now, Utah geography quiz. Which county is this? Iron County. Great. Trick question. What's the county seat of Iron County? Clark? Parowan. Not Cedar City. Okay, now I mentioned Central Iron County Water Conservancy District. Which county is this? Beaver County. All right. Those folks in Beaver, they're a little rabid sometimes, so got to be careful. But anyway, lo and behold, these rascals down here in Cedar City, they snuck up into Beaver County and they filed some applications to appropriate water in Beaver County. They want to use groundwater and then create an import project to pipe that water all the way down into Cedar Valley. Okay? Think folks in Beaver liked it? Not much. Anyway, so, but you can see from this particular map that there's not a lot of water that's there within those areas. So it'll remain to be seen whether or not it's actually going to work or not. You have any questions about anything that I've talked about so far? I want to make sure, again, we're coming kind of to the conclusion of this training. And what kinds of things do you want to talk about? Do you have lingering questions about? Yes, sir.
How many years are in the average to develop that stream flow graph?
It's just a hypothetical hydrograph. It wasn't necessarily, but it is typical of many streams within the state on any given year. Okay, so it's just an example. It's not necessarily an average or whatever. Anyway, any other questions? All right, let's talk some more about forfeiture. This has been talked about a few times over the course of the training. It's all covered by the Utah Code right up here. Section 73-1-4. Now I remember some 20 plus years ago when this was an insignificant small little section of the code, okay? And it basically just said if you don't use your water for 5 years, 5 consecutive years, it's deemed to be forfeited. And it didn't talk about how or what or when, any of that kind of stuff. And so, and keep in mind too that this is 2016. Most of the municipal filings that were made for groundwater applications were made in the 50s, the 60s, the 70s, when those applications to appropriate, we were still entertaining them and approving them. So you may have municipal entities that are pushing against a 50-year time limit, and then the law also at that time indicated that you can't extend a water right beyond 50 years. In order to, you can't make additional efforts to place it to beneficial use. You got to file your proof at the end of 50 years, basically. And so what happened was back in about 2006, we had an application that was within the Provo River drainage, Teresa's current neck of the woods, and was filed by a lady by the name of Marilyn Hamlin, and she wanted to move a water right from a surface source over to Highland City. That source is currently occupied by the BYU Film Studio. We go to the BYU Film Studio and they're saying, what water right? What surface diversion? We're hooked to Orem City. Why would we use the Provo River? Okay? And so it went round and round through the courts. Like I say, within the three branches of government, the judicial branch got involved and a decision was made on said lawsuit. And of course, the seller wants to wind up pushing this through. Highland City, they weren't sure what the heck they were going to get, but they were going to get an approved change application was what their hope was, to wind up increasing their portfolio of water rights that they had to draw from. But 7314 seems like it's been a hot topic in the legislature almost every year since. And so now it's expanded up to lots of different things. But I want to point out a few things to you. Right up here, when a water user ceases to use all or a portion of a water right, and it's not 5 years anymore, it's 7, for a period of 7 consecutive years, it can be subject to forfeiture. So you say, well, what the heck? How does this happen? Who determines if the water right is forfeited or not? Well, one thing is for sure, the judge told us that the state engineer, as an administrative authority, does not have the authority to declare water rights forfeited. That is a judicial action, and so it's a process in which one party has to wind up bringing suit against another, and then the judge says yes or no, it is or it isn't. There have been very few of these suits that have been brought within the state, okay? I mean, it's something that gets people's interest up, all kinds of different things. Just one second here, but anyway, I made reference to that Hamlin case, okay? There's a ton of money spent on legal fees for that thing. And then eventually what happened was the Central Utah Water Conservancy District stepped up and said, we're going to go through and we're going to bring an action for forfeiture against the individual who claimed ownership of this water right and wanted to make the change. And the end result was Central Utah was successful, but again, they spent a whole bunch of our tax money, wound up going out there and bringing this thing to court. And so, you know, it's an interesting thing when you're talking about water right change applications and whether or not a right is valid or not. I've been sitting in hearings around the state in the course of some of the duties that I have, and I remember down in the Richfield area, this is out, we actually held the hearing in Delta, but the applicant had filed an application to change a water right in which many years previous, lightning had hit the transformer for his well, and so his well was inoperable. And the local water users knew this, and they stepped up in force and objected to it. Is the water right forfeited? Probably is, but the state engineer doesn't have authority to say that. Okay, I can't remember what the disposition was in that particular change application, if the applicant withdrew it or if we actually acted on it and did not approve it. But anyway, it's an interesting process, and like I say, there have been very few lawsuits that have been filed, but it is a concern that action could be brought by someone. It's probably more likely to come out when the state engineer's office is adjudicating areas and we go out and we identify rights that are not in use. Sir.
Who wrote that law? All or a portion? How much of a portion? What's a portion? A gallon? 1 CFS? What are we talking about here? Does it say 7 consecutive years? I thought you said consecutive years.
I did say consecutive years because that's what's inferred.
Oh my goodness. Who are
If
these
you,
guys
if you
that are
want
writing
to,
these
if you want to
laws?
say that it's for a period of 7 intermittent years,
We
I
were a
think you're going to
gallon
have a hard
short
time.
for 6 years.
Well,
I'm going to take it.
it's not going to be
Get
something
the
that.
shovel.
Okay, great. It's not going to be contested. I can assure you of that.
And John, it talks in the statute about using essentially all the. I mean, if you use essentially, so if there's portions of it that aren't being used, a small percentage, the legislature just said, you know, you need to be trying to use it all, and you need to use essentially all of that water. But it does imply that there might be small portions of it, or that cupful that you took out and didn't use it. I don't. They
We're
didn't
not trying to
define what
split hairs
essentially
with
all
this.
was. What's that?
I say we're not trying to split hairs with this. I mean, it says all or a portion, but again, as we continue the conversation here, you might see where the portion bit of it comes into play. I don't know, but anyway, like I say, within a general adjudication, you have instances in which rights are identified that are not in use when the adjudication team goes through. And so they're recommended to the court as being disallowed. And when the court issues a decree declaring that right to be disallowed, the effect is the same. Okay? So if you want to go through and you're a water user that thinks that you want to go challenge a water right for forfeiture, you have to bring that suit within 15 years of the most recent period of non-use of at least 7 years. If you're going through, and again, there's no magic slush fund of money that the division provides or anything like that for you to wind up taking on this judicial action. It's all money out of your pocket. So there's, again, not very many instances in which these forfeiture actions are actually taken on. Question?
You know, we live in a dry state, and so where does conservation play a role here? Why it seems like we're being forced to use this water, but yet we're being pushed and pressured to be conservative. I'm getting mixed messages.
Okay, conservation is important. I agree wholeheartedly. But again, I'm just saying that within what the state law is as it exists, they want you to make beneficial use of the water because that's part of what's been tied to the state's economy for forever. Okay? Yes, sir.
Well, just to follow up on that, my neighbor here to the side of me from Rich County pointed out that wouldn't it be the land that we're looking at? So when we talk about using the water, if you had 20 acres and you only put 10 of them to use, then you're showing that 10 was that portion perhaps that wasn't used. And I think yesterday, didn't we talk, we may have talked a little bit about the fact that we could have conserved the water, but perhaps if it was being used over all that land was still all being put to beneficial use. Even though we're conserving it, we still have the right. We're not going to lose it in the future, but perhaps if you left half of that land without irrigating it, then that may trigger this concept.
Okay, very true. We'll talk about that a little more as we go along here. Again, as part of this, when you have an adjudication and you have this, what happens is you have the proposed determination book that represents the rights, the claims that individuals have put forth, and we're going to talk a little more about adjudication after I sit down. But the decree that the judge signs finalizes those rights, and it prior to the issuance of the decree, the non-use is not something that you can wind up contesting. But non-use after the decree is something, again, that you can wind up going after. Okay? And there oftentimes you'll find that one of the things that happens is you'll find somebody that says, well, the water, it's just there and it's been used by my neighbor. Again, something that you hear commonly, but that's what the statute says, that if it runs to waste or if it's used by others without right, the statute still applies. Okay?
Will a lease cover that right?
Yes. Number one, if you've got a lease or another agreement with an appropriator, and again, these are some of the things, the exceptions to the forfeiture law under 7314. And you probably, if you want to get on your electronics here and get out there and take a look, you can see that section of the code on there. But if there's a lease or another agreement that the appropriator has entered into, again, I recommend that you file a change application to wind up making sure that that is a matter of record. You can even file a temporary change application if you want, but that makes this section not apply. Some of you may enter property into fallowing programs, that kind of thing. You may, as I indicated on that other slide with the hydrograph where water is not available, okay? So you can't wind up trying to invalidate a later priority right simply because the water is not available for that right during specific periods of times. And again, for streams and surface sources around the state, what happens is most of those are regulated by river commissioners that represent the state engineer's office, and so they go down through and they keep keep tabs of the amount of water that's available in the sources, the flow of the streams and rivers and reservoirs, and then they determine how much water is available for which priority, right? And then they can cut people off, okay, during those times when they're not entitled to that under their priority. So if the source of supply doesn't provide adequate water, again, it's not something that causes that right to be subject to non-use. And like I say, under distribution of water, if they have a priority restriction, I'm going to talk a little bit in a minute about groundwater recharge projects. And so again, if the water is being used in a groundwater recharge project, it provides that exclusion. And probably most significantly, if there is an approved change application for it. So those folks who are here that are representing public water supply entities, cities, and that kind of thing, that ought to perk your ears up. You know, if you've got a water right, you're worried about it, the legislature has bent over backwards trying to wind up helping you protect those rights from forfeiture and enable you to use those for any future needs that you as a water supplier have. And having that change application is one of those. And I'm going to wrap this up. I know this has got to be drier than dry, but again, this is another section of 7314, and it basically, unless the appropriator or successor in interest files a non-use application with the state engineer. And so again, you file your non-use application, the previous 7 years are covered. If you are an irrigation company and you have shareholders who may or may not be using their water, again, that shareholder is entitled under the statute to wind up filing that, obviously notifying the company. But if you look over here amongst the list of things that are required on a change application form, probably the most significant of those is in the next to the last, where it says a statement of the reason for non-use. So there are specific reasonable causes, if you will, that the legislature has incorporated into this statute, and this is what it says: a financial hardship or economic depression. So you folks that grow hay, if the economy went to crap and you wound up having more cost to produce the hay than you can get out of it when you sell it, I suppose that could be economic depression or financial hardship, but anyway, but it's that sort of thing. And then if you have water conservation or efficiency practices, you know, again, you're placing the water that's needed for your beneficial use, you're using that water, okay? And then recharge and recovery program, and then the operation of legal proceedings, and then you can read the rest of them. But anyway, but as was indicated in a prior presentation, if you have a water right and you're holding that for the future needs of the public by a public water supplier, then that again is another reasonable cause. But you need to cover that with your non-use application. So the state engineer's office obviously could approve or reject these non-use applications, although I think 99.9% of them are probably approved. And since we're talking about non-use and forfeiture, I have one of these aerial images from the division's website incorporated into this presentation. I want you to take a look at it, see what you might think about what might be something that may impact water rights relative to non-use. So that you know, down to the bottom, if you keep following this is Interstate 80, you'll hit Wanship. You can see this is Colville. To the north of that is Echo Reservoir, just barely off the page. This is Interstate 80 as it motors along through here. This is the Weber River. So you've got Wanship Dam, Rockport Dam that's delivered water into the river system. It proceeded through here. And my guess is the river's been realigned a little bit when the highway got built. But can you see areas in which you might have water rights that have previously existed that may be affected by non-use now? What if you had water that was diverted into a ditch and now covered by this big interchange? What about the expansion of urbanization, if you will? I know that Colville's not exactly a real metropolitan center, but still. I just want to point out to you again that there are instances in which obviously Interstate 80 has existed since the 70s, okay, for well over 7 years, and kind of surprised if someone would actually think that that irrigation could occur. And remember the part of the statute that I talked about before where that forfeiture statute applies whether the water is basically used without a right or it runs to waste. So we'll leave that one. Now we'll talk a little bit about quantity impairment. This is a new section of the statute, just got adopted this year, and so we're still trying to wind up figuring out how to wind up dealing with it. But in regards to quantity impairment, there's a definition of it, and this is all straight out of the Utah Code. So, but it's a reduction in the amount of water a person is able to receive in order to satisfy an existing right to the use of water that would result from an action proposed in a change application. Okay? So, there are the three instances: diminishing the quantity of water in the source of supply for the existing right, and then a change in the timing of the availability of that water to the water right holder, and then enlarging the quantity of water depleted by the nature of use that's proposed in the change application. Okay? The quantity impairment, however, you have instances in which those of you, again, who are familiar with well hydraulics, when you have a well that you put into an aquifer, you start pumping that well, it has an impact immediately around the well. And so there's a cone of depression that results from the water that you've removed from the aquifer by virtue of pumping the well. And sometimes when you get multiple wells and larger diversions of water from the groundwater, it can cause a general decline of the water levels within those aquifers, within that supply that's generally available. And this provision excludes that from quantity impairment. Any questions? Okay, we're going to keep talking about this a bit because this is really kind of the sort of a budding hot topic, if you will. But so in a proceeding before the state engineer, what do you think it means by proceeding? Again, it's a change application process that initiates an adjudicative proceeding or action before the division. But notice that this section of the statute states that the applicant on the change application, the person who is proposing the change application, has the burden of producing evidence sufficient to support a reasonable belief that the change can be made in compliance with this section and with 7338. Okay? So there are two methods of doing that. They have to show that the change will not cause a specific existing right to experience quantity impairment, or they can rebut the presumption of quantity impairment described. You refer back to that map that I showed you of Colville. If someone has a water right that is identified within the Weber River Decree as being on land that's now occupied by Interstate 80, what happens? You think there's a rebuttable presumption there that that water right has been lost? Well, we might have been born yesterday, but we kind of think there might be. So anyway. And so to continue along this line, this is a different section of the code. This is 7338. And again, these 7338 is the criteria that the state engineer is charged with in acting on applications, either approving or rejecting them, okay? And so when we go down through, it says that where the state engineer is to reject the change if the person proposing the change is unable to meet the burden that I previously described to you. And then if it's otherwise proper, we may approve that change application. We can choose to wind up approving it for part of the water, that the applicant acquire a conflicting right in order to cure that impairment that's going to happen, that the applicant provide and implement a plan that they would present to the state engineer that we would approve to mitigate that impairment. And again, this is all pretty new stuff. We're still trying to wind up feeling our way around as to how it's all going to work, but there you go. And then another section of the 7338 code, And this talks again about this rebuttable presumption of quantity impairment. And so again, it's the applicant's duty to wind up presenting sufficient evidence to rebut that assumption that a quantity impairment will recur. So, any questions on that? I'm going to keep moving along here anyway. I don't want to beat quantity impairment beyond death. So we go through, and let's say that you're an existing water user and you've got a water right out there. And I don't know that we've talked too much about this, but the division is required when an application is filed to provide a public notice or a notice to water users that an application has been filed. It's by statute. Now, you have to understand the Utah Code came into being in about 1903, and it's been kind of evolving somewhat slowly, if you will, through the years, but there is still that provision for us to provide public notice of applications that are filed with the division. The way that we do that is by a newspaper publication of a paper that's distributed locally. Now, we recognize that you guys are probably like me. I happen to subscribe to the Deseret News, but I never even open the paper because I've already looked at everything online or something like that, so there's really no need for it. I don't know why I subscribe to it, but what the heck. But maybe you're up in Summit County and you're looking at the Park Record, or you're looking at the Summit County Bee, or you're out there in Tremont or Brigham City and you're looking at the Leader, okay? That's where you pick up on these notices. But, as James Greer has pointed out, there is a way that you can go through and you could electronically track what applications are filed with the division. And so the reason that this is significant is that under this quantity impairment thing, if somebody files one of these unusual change applications, shall we say, this is what the statute says, that we, the state engineer, may not consider quantity impairment based on those previous conditions. In other words, non-use, unless, okay, the issue was raised in number one, a timely protest. So as a water user, keep track of these things. Know what's being filed in your area so that you know whether or not you need to object to these applications that are being filed. There's a specific protest process that's identified there within that newspaper publication. Basically, you got to file a written protest and pay a $15 fee. And then raise this quantity impairment thing if you think that's something's going to wind up happening as a result of another application being implemented. And then, but more specifically as it affects the division, if we go through and we see something that we think is an egregious kind of thing, we can provide a notice to the applicant. And we have to do that within 90 days. This is DII. We have to file that within 90 days of when the change application is filed, okay? So we say that, again, there have been instances where people are trying to wind up asserting that they have a water right that's under Interstate 80 or something like that, and we want to file some change to wind up doing something different. So, and then I've got one other slide here on this, at least one more, but so this is an excerpt from the letter that we offer to you. Again, just talking about the quantity impairment thing. Again, I'm sorry, I got so stinking many slides, I'm getting a little lost here. But this is actually an excerpt from our letter. But this is what we say, that, you know, again, we're giving the applicant notice and thereby establishing their obligation to meet that rebuttable presumption of quantity impairment. So I'm going to go ahead and leave this. Do you have any questions on quantity impairment? These are just some general questions. Okay, what would it be? Nope.
Going back to that picture, the guy standing in the ditch with a staff gauge, thinking of Colville, they put in a pipeline system so the quantity in that ditch could be changed because his neighbor's water may have went through that. It may have sub-irrigated his ground. As long as he gets his share of water, is that a quantity impairment?
I would say if you're the water user is being impacted by the project, you may feel that it is, but again, that's something that would have to be evaluated as it goes. But generally speaking, these things are change applications. The quantity impairment issue centers on change applications based on rights that are involved in non-use.
Well, that would be a diversion question because these neighbors upstream would have diverted theirs a different way, which he may, as long as that's his water right there that he's getting, the flow through him may have changed.
Okay. I would only offer to you this little axiom from my experience with within water use. Priority beats priority.
Well, it does, but until you put in a pipeline.
Okay. Anyway, but lots of different little side issues we could talk about. And I've only got like 8 minutes left, and I'm going to have to turn this over to someone else. So I'm going to try to cover a few more topics. But I want to make sure that, again, I know you guys are all concerned about the big test, and really you shouldn't be. It's nothing. But just as you're thinking about these kinds of issues, impairment of water rights, what actually constitutes impairment of a water right? We've talked about groundwater kinds of things. If you have a spring and you have a well that goes in nearby and all of a sudden your spring goes dry, do you think you've been impaired? You probably have. But again, it's a judicial action to wind up establishing that impairment has occurred, just as it is with forfeiting a water right. So again, the reasonable causes for non-use. Remember we covered those a little while ago with the financial hardships, those kinds of things. In the non-use application, it protects a water right from the date of filing of that non-use application forward. And it can go back for the previous 7 years, but it doesn't really extend prior to that. So the last one, can a non-use application be filed for a period of non-use from 76 to 86? Suppose that it could. Does it actually cover non-use for those periods of time? That may be a subject that you'll have to address at some time in the future. But again, if it's one in which by choice of the water user, the water has been available and he has chosen not to divert and use it, that could be an issue for that water right holder. So anyway, just a few things to wind up considering. When is it not subject to forfeiture? Always when the water is being used, again, as Kent indicated in response to one of the issues that was brought up about a portion of the water right, it says substantially all or reasonably all, something to that effect. So again, if you're making those efforts to wind up using the water, I think you're covered. And you have to commence those judicial actions should you wind up going through and just trying to enter into one of those within 15 years of the non-use occurring. So non-use applications, change applications, those also protect water rights from forfeiture. Now, got any irrigation companies here? I know we've got a few. Okay, you're talking about a share. Tamara yesterday in her presentation talked a lot about what it means when somebody comes to the office and they say, I've got a share, I want to do this. You know, sometimes you have to scratch your head a little bit and say, well, what are you really saying? And so this is what this means to us. If you have a share, you're referring to a share of stock. Usually it's in an irrigation company, and that share or stock represents just the right of a shareholder to be delivered water proportionately by the company, and then the company diverts it under their water rights, okay? So a water right is a specific property right, though, and the irrigation company, when you have shares of stocks that you've issued, that's a legal document and everything, but it is not a water right. A share is not a water right, okay? And so the irrigation company owns those rights, and those form the basis of what can be diverted and used. So those of you that are with irrigation companies, others of you who may be consultants that may have people who say, well, I've got shares of stock, I want to go do this big project. What do I do with the shares of stock? Those of you who are cities, you probably have provisions for people to wind up bringing you shares of stock or other water rights in case developers want to go through and they want to develop things. So here you go. Here's under 73.3.5 covers this. And again, these are the applicant's responsibilities. They have to detail to the company. And basically, they're the shareholder. The company can say yes or no. But this is what the applicant has to do. So they have to detail what they want to change. A lot of times these become somewhat everyday to the company. The same sorts of things come in. You know, like you're up South Camas or you're up there in Beaver Street, Shingle Creek Irrigation Company up in Summit County. They take shares of stock, they transfer them over. The division has, or the company has a set way that they wind up dealing with those to wind up establishing the rights to drill a well for a home. Okay, so, but those are the continuing obligations of the shareholder. And so keep in mind under this, this last one right here, they think that, well, okay, I've changed this out, so I've separated my duty to the company. It's not the case. You have a share of stock. You have to maintain that share of stock with the company. You can't go through and say, well, I've got my well, the heck with the company. I'm going to sell my share of stock to someone else, because then you're expanding the water right, okay? So they have to pay those assessments. And then they have to file that change application. It has to be signed or otherwise authorized by the company. Anyway, and if again there's a time limit on it, the shareholder can request the extensions of time through the division. These are the company's responsibilities. So when the company receives a request to make a change on their stock, they have 120 days to wind up making a decision. And so they can do those things that are listed. They can go through and they can, you know, approve the request and impose conditions of one sort or another, or they can approve it outright or deny it, whichever they choose. And again, if they don't respond within 120 days, it is deemed to be a denial of the applicant's request. So, and again, I'm not going to wind up belaboring these things. You know, you can call us if you want. But again, keep in mind that these are some things, some questions that you might be interested in hearing in about a couple hours. When an individual wants to file a change application based on shares of stock in an irrigation company, what does he do? Okay. I'm sorry. That's what they has to do. Details, provide the details. Might want to come into the division and have a change application form, a draft change application form prepared to present to the board of directors so they can see that, okay? And then when the irrigation company receives a request to file a change from a shareholder, what should it do? I guess the kind of simple answer would be to act reasonably with the shareholder and not say we've been in irrigation for 500 years and we want to stay just an irrigation company. You know, it's unfortunately with the way things are with most of the state where people live, being closed to appropriations, that's one of the realities that shares of stock in irrigation companies wind up being changed. And so again, how could an irrigation company incur liability? There are probably 99 different ways that the irrigation company could incur liability, but primarily in the circumstance of having change applications based on shares of stock is if they do something that is outside of what the statute has directed. And again, share being the same as a water right, we've covered that. So now, you have any questions about that? Yes, sir.
On an irrigation company share, say a shareholder does not use that share and it goes for 7-8 years.
Is that share subject to forfeiture or?
Okay, the question is if a shareholder does not use the water from the company for a given period of time, could it be subject to forfeiture? And the answer is yes, it could. But again, these kinds of things because it is a judicial action, somebody has to pay the money to wind up bringing this thing to court. And again, I don't want to have you believe that by bringing a forfeiture action, that the person bringing the action, if they succeed in having that water right declared forfeited, that they get the water right, okay? It just goes back into the common pot that's there and available for all water users generally, all of those water right holders. So it just makes those other rights that were a little bit borderline in terms of priority and supply a little more whole, a little more able to develop a full supply. The individual that brings that action succeeds in killing off that piece of that water right, but they really don't get anything out of it. So it's counterintuitive to me that a person would even want to bring one of these things, because it just is nothing but an expense, and then you probably get shot by your neighbors, okay?
If you have a metropolitan water company that's a shareholder, if you have a metropolitan water company that's a shareholder in your system, could they potentially go file for forfeiture against a shareholder who didn't have it?
It's possible, but anything's possible. I mean, we could get hit by a meteor here in 5 minutes and all be dead, but you know, I really don't think that's too concerning, but if you have a specific instance, I would suggest that you call the regional office that's involved with it. So I wouldn't lose sleep over it, let's put it that way. All right, wastewater reuse. Sorry?
Your jokes are getting better.
Okay, good, I'm glad. I am kind of an engineer, so I'm a pretty dry humor guy. But wastewater reuse, this is really only applicable to municipalities. You have to have a municipal water right to incorporate into a wastewater system. You remember Ross Hansen's presentation yesterday where you have municipalities who are trying to file proof on some of these appropriations that they have, okay? This is where if you're a municipality and you have an old groundwater right that's for 5 second feet for municipal uses, the division's approved it, okay? And either approved it or maybe you've even got a certificate on that that allows you to develop the 5 second feet. That's where these things are good as gold. Because within these wastewater reuse projects, they can divert and deplete pretty much whatever they're plugging into the system based on those old municipal water right applications. Now, if you're thinking that you're going to run right out and you're going to file one of these, I can only say this, that we've been doing these for what now, about 15 years, Kent? These wastewater reuse applications? 15, 20 years, give or take, and there have only actually been 17 applications that have been filed. And of those 17, I doubt there's half a dozen that are actually reusing water. But you go through and you can take a look under some of these things. There's some of the things that the application has to include. And then, any questions about reuse? Quickly? I'm eating into the time of my compatriots, and he's only got 15 minutes, so he's probably thinking, keep going. Groundwater recharge and recovery, again, this is one of the most complicated applications you can file with the division. And I'm trying to think here, I've got it written down, but I think there's 11 of these recharge applications that have been filed. There's 2 steps to this, is the recharge application and the recovery. Now, if you look at a whole bunch of areas, because of pumping of groundwater, there are impacts to the groundwater. Groundwater levels are declining, those kinds of things. Frank Quintana a minute ago held up a book that was Groundwater Conditions in Utah, where they go out and they monitor a whole system of wells to try to determine where the groundwater levels are at. And most of the groundwater levels in the state are declining to one degree or another. Some of them significantly, some not so much. But that's the thing that's critical. One of these applications, if any of you drive along Highway 89 near the mouth of Weber Canyon, you've been within a stone's throw of a recharge project that is done by Weber Basin. You probably didn't even know it. But anyway, the trick is sometimes you can get the water into the ground, but then where does it go? Difficult to wind up tracking. And in the case of some of these things, how long does it stay in the ground, and can they actually recover the water that's been recharged? So there are 2 parts to this, and I will only say this, that the application fee for a recharge application correlates to the amount of water that they're proposing to recharge. The recovery application, which is the second part of that. It's a $2,500 application fee. So again, there are just not many of these that are filed. Okay, same sort of process. I'm just going to let you go with that. Frank again talked about water use reporting, and within that system there's a storage account for these recharge and recovery applications where you're obligated to report on those kinds of things. Let me see if I can find my slide on this. As you can see, I went way overboard with this, but I hope you've gotten something out of it besides being bored. But anyway, the state engineer is supposed to establish a storage account for these recharge projects, and then they have to report what are they recharging, and ultimately I'm hoping what are they winding up recovering. And hence, gratefully, we have come to the end. You have any other questions? I have a few little questions here you may be interested in. I've kind of asked a few of them along the way, but you have to understand again, this test is comprised of a group of a couple of hundred questions, give or take, and I think there's 100 of them that are randomly selected for what you take. But within what I've covered, like you have an individual that wants to file a change application based on shares of stock. What does he do? We've covered that one, right? The company that receives a request for change from a shareholder, what do? Okay. Consider the request if it has sufficient information to act on it. Its obligation to distribute water to other shareholders. How does that change application? How does that application request affect those? The land that's been previously irrigated, is it going to be retired? Those kinds of things, okay? And the irrigation company could incur liability by allowing corporate status to become invalid, using sources that are not included in its rights, and unreasonably withholding approval of a change application or something to that effect, okay? And then some of the others. Here's my favorite. I'm going to leave you hanging for the rest of them. Which of the following is true relating to a change application filed in 2016 on a water right approved to irrigate land that is now occupied by a Walmart built in 1996? Okay, we'll let you think about that one. Is it a possibility Walmart may own that water right? If they own the land, the water right's pertinent to it, is it not? So if you want to find out, well, gee, it's been 20 years. Has a non-use application been filed on that by some water right holder? Did they separate it as an appurtenance? You can find all that stuff on the division's records. And anyway, so we'll let you have a little fun with all those. And any other quick questions? I figure we're probably just eating into lunchtime, so you guys will have to get a sandwich and do a working lunch or something to that effect. Thank you very much for your attendance.